Hello, and welcome to the second of three audio recordings of articles I've authored on using letters of credit as a credit enhancement tool. I'm Ray Patella. I'm an attorney with Kramer Burns, a full-service law firm located in northern New Jersey, primarily serving business clients in corporate matters, commercial transactions, real estate, litigation, and bankruptcy creditors' rights. We also assist individuals with estate planning and residential real estate needs. I practice in the areas of creditors' rights, insolvency, bankruptcy, distressed transactions, and litigation and other business law matters. Credit professionals often act as checks and balance against their sales department's potential risky attempts to bring in new accounts in their yearn for revenue. The credit department is responsible for evaluating the risk proposed by a new account and suggesting ways to either minimize that risk or enhance the creditworthiness of the new applicant. This second of three sessions focuses on why letters of credit are preferred over other forms of credit enhancements and how to stop a draw of an LC in a bankruptcy case. LCs are frequently preferred over other credit enhancements such as third-party guarantees, security deposits, and liens on assets, all of which would likely be affected by a customer account party's bankruptcy case. For example, if the vendor held a security deposit or lien on assets, the vendor would be prevented by the automatic stay from taking any action to enforce its secured claim during the bankruptcy case, absent a bankruptcy court order granting it relief from the stay. Similarly, the third-party guarantee, if secured, may be essentially worthless if the guarantor also files a bankruptcy case and the property is valueless. General principles of bankruptcy law reinforce the independence of the issuing bank's obligation to honor drafts under an LC transaction, as opposed to the bank's rights against the now in bankruptcy customer/account party. Even after a bankruptcy petition is filed, the creditors remain free to transact among themselves, including the ability to freely trade claims. A bank honoring an LC is just that, substituting one creditor for another. Bankruptcy law automatically stays any act to obtain a debtor's property once the debtor files for bankruptcy. However, the general rule is that if a vendor's customer defaults on its obligations to the vendor and subsequently files for bankruptcy, the vendor's ability to make a draw under an LC, securing the customer's obligation to the vendor, generally shouldn't be unaffected by the bankruptcy and should not be stayed or enjoined. Note, however, there are some exceptions. Since the Bankruptcy Code was enacted in 1978, some courts have held that a bankruptcy court has the ability to enjoin or stay payment on a letter of credit by a bank to a debtor's customer under certain circumstances. These exceptions have found that payment of the LC would somehow have a negative impact on the debtor's bankruptcy reorganization efforts. Regarding preferences, the general rule is that draws on an unsecured LC within the 90 days immediately preceding the bankruptcy filing generally should be immune from attack in a bankruptcy case as a preference. LCs, however, are not absolutely immune from avoidance as a preference. For example, in response to issuance of an LC during the 90-day preference period, this may constitute an avoidable preference under the Bankruptcy Code. Some courts have also reasoned that if the purpose of the LC transaction is to secure payment of a debt previously owed to the creditor, and there is a simultaneous pledge of collateral to secure the issuing bank, this may be a preferential transfer because a secured vendor, the issuing bank here, would then be substituted for an unsecured creditor, here the vendor, to the detriment of other unsecured creditors. As explained before, courts generally characterize the beneficiary creditor's payment demand under an LC as not involving property of the debtor's estate. Therefore, a draw should not be enjoined by a court. A few bankruptcy courts, however, have prevented a draw on an LC post-petition. In one case, a debtor convinced the court that the collateral that backed the LC was absolutely necessary for the reorganization of the estate, and that the estate would be irreparably harmed if the beneficiary were permitted to draw. Other courts have cited the debtor's ability to claim irreparable injury arising from a higher rate of interest payable on the reimbursement obligation to the issuing bank as compared to the rate of interest, if any, that may be payable to the beneficiary under its contract, and thus courts have enjoined draws under the LCs. Critics of these cases note that if an LC draw could be enjoined simply because of an account party's bankruptcy, the LC would lose its defining features of independence and prompt payment, and that there is a great public interest in upholding LCs because without them, many types of financing could or would not occur. Some courts also reason that they will enjoin a draw on an LC because bankruptcy is intended to promote equality among similarly situated creditors, and in the case of a draw under an LC, one unsecured creditor will be treated more favorably than the other. Of course, critics of these cases argue that the creditors are not similarly situated, that one bargained for additional credit protection as compared to the other. Most cases enjoining draws on LCs in bankruptcy appear to be in the minority, and these decisions have been criticized by authors discussing the cases. In conclusion, we have discussed the preference of letters of credit as a credit enhancement tool and how to potentially enjoin a draw on an LC in a bankruptcy case. Vendors and other parties in complicated commercial transactions are advised to seek the advice of counsel to minimize credit exposure in any given transaction by ensuring that the proper letter of credit is in place. Please tune into the next session in this series, which will address how to stop a letter of credit draw outside of bankruptcy. In the interim, thank you for listening to this update, and please contact me at 973-912-8700 or via email at rpatella@kramerburns.com. I'm pleased to answer additional questions that you may have and discuss your specific situation.